In a move that could reshape gun purchase laws across the nation, the Supreme Court issued an emergency stay that challenges the need for government-issued permits. Residents in states like Maryland, New Jersey, and Massachusetts might now be able to acquire firearms without official approval, effective immediately. The court's unprecedented 6-3 decision came late on Friday, granting a nationwide preliminary injunction that halts enforcement of permit-to-purchase rules in 8 states. This ruling applies while multiple consolidated legal challenges continue to move through the courts. Chief Justice Roberts, writing for the majority, emphasized that requiring government permission before buying firearms lacks historical precedent under the Bruin framework and constitutes a prior restraint on constitutional rights. The immediate impact touches Maryland, New Jersey, Massachusetts, Connecticut, Hawaii, Rhode Island, New York, and Illinois. Gun owners in these states can now legally purchase firearms without permits, pending final judicial determinations. Although the injunction creates a significant shift, federal background checks through NICS will still be required, and age restrictions along with prohibited person laws remain in force. 8 states currently enforce mandatory purchase permits, and these schemes were challenged in court as violations of Second Amendment rights. On Friday evening, the Supreme Court consolidated the cases and issued the emergency injunction to block enforcement until the courts reach a final verdict. The reasoning behind the ruling draws on historical analysis. The court found that during both the founding and Reconstruction eras, there was no tradition of requiring government permission to buy firearms. In colonial America, firearms were typically obtained from gunsmiths without any official authorization. Permit laws emerged much later, in the early 20th century, more than 100 years after the Second Amendment was ratified. Under the Bruin standard, the absence of historical analogs renders such permit schemes presumptively unconstitutional. Chief Justice Roberts' opinion clarifies that permit requirements function as a prior restraint, analogous to requiring government permission before exercising free speech. Just as the government cannot condition speech on discretionary approval, it cannot impose permit mandates on firearm purchases without historical justification. These schemes grant officials broad discretionary power to delay or deny the exercise of constitutional rights. As a result of the court's ruling, the emergency injunction immediately prohibits states from enforcing permit-to-purchase laws. Citizens cannot be prosecuted for purchasing firearms without a permit, nor can sales be denied due to the absence of government authorization. While these permit systems are temporarily blocked, background checks under federal law remain in place, and age limitations as well as prohibitions against certain individuals retaining firearms continue to apply. Procedurally, the court consolidated 8 separate lawsuits from Maryland, New Jersey, Massachusetts, Connecticut, Hawaii, Rhode Island, New York, and Illinois, following a mix of lower court rulings. Writing for 6 justices, Roberts, Thomas, Alito, Gorsuch, Kavanaugh, and Barrett, Chief Justice Roberts highlighted that such permit requirements represent prior restraints on fundamental constitutional rights and must meet stringent historical justification, which they fail to satisfy. The court's analysis traces the lack of historical precedent, noting that colonial Americans freely purchased firearms, while early regulatory measures focused on licensing gunsmiths rather than buyers. The first government-issued permits appeared in the early 20th century, roughly a century after the Second Amendment became law. This historical gap, according to the court, supports the presumption that permit mandates infringe upon Second Amendment protections. By analogizing permit requirements to restrictions on free speech, the court underscored that government officials should not have the discretion to preemptively block the exercise of constitutional rights. Under this emergency ruling, all 8 affected states are prohibited from enforcing their permit-to-purchase schemes. Individuals in these states can now proceed to acquire firearms without needing government approval, though NICS checks and other existing legal restrictions remain in effect. The Supreme Court's order applies immediately, suspending enforcement and preventing states from penalizing or denying firearm sales due to lack of a permit. While the broader litigation continues, this ruling fundamentally alters the legal landscape for gun ownership in the affected states, striking a powerful note in the ongoing national debate over Second Amendment rights. The Supreme Court's emergency injunction targets only state-level permit-to-purchase requirements, leaving other regulations untouched. Justices Kagan and Jackson dissented, arguing that issuing emergency relief before full briefing was premature, cautioning that regulatory confusion and risks to public safety could follow. The majority, however, held that when fundamental constitutional rights are threatened, immediate relief is justified. The impact varies across states. In Maryland, the prior requirement of a handgun qualification license, or HQL, has been lifted. Handgun purchases now proceed with federal NICS checks alone. New Jersey residents no longer need firearms. Purchaser identification cards, FPIDs, or handgun permits, federal background checks are the only requirement. Massachusetts previously mandated either a firearms identification card, an FID, or license to carry, an LTC, but now state permits are no longer necessary for purchases. Connecticut had required a pistol permit or eligibility certificate. That requirement is suspended, leaving only federal checks. Hawaii's system of county-issued permits for each acquisition has been nullified. Rhode Island previously demanded local pistol purchase permits, which are no longer enforced. New York's requirement for state-issued pistol licenses has been blocked, and Illinois' firearm owner identification, or FOID, is no longer a prerequisite for buying firearms. Certain federal safeguards remain fully in effect. All firearm sales through licensed dealers continue to require NICS background checks. Age restrictions persist, 18 years old for long guns, 21 years old for handguns. Prohibited person laws, covering felons, domestic abusers, and similar categories, continue to apply. Existing assault weapons bans, magazine capacity limits, and carry permit obligations are unaffected. The ruling only addresses purchase permits. Starting immediately, residents in affected states may acquire firearms from federal firearms licensees without any state-issued permit. Purchasers must complete the federal Form 4473 and may take possession of their firearm as soon as the NICS check clears, without waiting periods. Ammunition can also be purchased without permits. Massachusetts residents remain bound by federal prohibitions. Felons, domestic abusers, fugitives, unlawful drug users, adjudicated mentally ill individuals, those dishonorably discharged from the military, and persons subject to restraining orders still cannot acquire firearms. Age restrictions for handguns under 21 and long guns under 18 continue. Acquisition of assault weapons in states with AWBS laws remains a separate legal issue. The decision does not affect carry permit requirements. It applies solely to purchase permits. Interstate purchases still require licensed dealers, and private sales between residents of the same state, previously requiring permits, may now be permissible under state law, though federal rules remain in force. Using federal firearms, licensees even for private sales, is recommended to remain compliant. Some local authorities may not yet understand the new ruling, so carrying copies of the court's order is advisable. States may issue emergency guidance or implement alternative regulations, and residents should monitor these developments closely. States are already reacting. Maryland's Attorney General directed state police to suspend HQL enforcement, while emphasizing that other legal obligations persist. New Jersey's governor labeled the ruling reckless and announced plans to seek clarification. Massachusetts is exploring regulatory alternatives consistent with Bruin, such as mandatory training programs unlinked to permits. Connecticut convened an emergency legislative session to consider measures like mandatory waiting periods, firearm training, and enhanced background checks structured without calling them permits. Illinois is drafting legislation that would require proof of insurance, training, and secure storage prior to sales, effectively delaying acquisition without issuing formal permits. Rhode Island is considering enhancements to dealer licensing that could serve similar functions as permits under another name. Law enforcement agencies across these states are adapting. Issuing guidance to ensure compliance with the new Supreme State Attorneys General are moving quickly, issuing guidance to halt arrests for purchasing firearms without permits. Pending permit-related charges are being dismissed, and processing of new permits has been suspended. Meanwhile, enforcement of all other regulations, including federal prohibitions for certain individuals, assault weapons bans, and carry permit rules, remains in effect. The Bureau of Alcohol, Tobacco, Firearms, and Explosives has directed licensed dealers to complete sales using Federal Form 4473 and NICS checks alone, without requiring any state-issued permits, while maintaining strict federal compliance. On the federal side, the Department of Justice is reviewing the Supreme Court's ruling and its implications. Federal law continues to operate fully. Prohibited persons remain barred from acquiring firearms. There is currently no indication that the DOJ will challenge the emergency injunction, as doing so would be both extraordinary and unprecedented. States may petition the Supreme Court for clarification or modification, though success appears unlikely given the 6-3 majority. The ruling may also accelerate appeals in lower courts, expediting final resolutions. As for the current legal landscape, the emergency preliminary injunction blocks enforcement of permit-to-purchase laws, while the cases continue through the standard appellate process. The Supreme Court consolidated the cases to grant emergency relief, but it has not yet ruled on the merits. Over the next 6 to 12 months, district courts are expected to conduct trials on the substantive issues, and circuit courts will review those decisions. The ordinary appellate process continues despite the injunction. States will argue that permit requirements serve compelling purposes, such as preventing trafficking, ensuring responsible ownership, reducing impulsive acts of violence, and having historical precedent. The Supreme Court will eventually grant certiorari to resolve conflicts among circuits and issue a final ruling on whether permit schemes violate the Second Amendment. Earliest argument dates may fall in the June 2027 term, but more likely the cases will be heard in the June 2028 term. The emergency injunction remains in effect until a final decision is rendered. Potential outcomes are varied. The court could strike down all permit requirements as unconstitutional, making the emergency injunction permanent. Alternatively, it could uphold certain systems that have adequate historical analogs or are narrowly tailored, modifying or lifting the injunction. A third possibility is remanding cases for additional fact-finding, leaving the status of the injunction uncertain. This ruling also signals the court's willingness to use its emergency docket aggressively for Second Amendment matters, suggesting that other regulations may receive similar rapid consideration. Measures such as assault weapons bans, magazine limits, and restrictions in sensitive locations could be subject to emergency review in the future. To summarize, the Supreme Court issued an emergency preliminary injunction halting permit-to-purchase enforcement in 8 states: Maryland, New Jersey, Massachusetts, Connecticut, Hawaii, Rhode Island, New York, and Illinois. Effective immediately, residents may purchase firearms from federal firearms licensees without state permits, though federal background checks, age restrictions, and prohibited person laws remain intact. Assault weapons bans and magazine restrictions continue where they exist, and carry permit requirements are unaffected. The court's reasoning emphasizes the absence of founding or Reconstruction-era traditions requiring government-issued permits before firearm acquisition. Colonial Americans freely purchased guns, and the first official permit laws emerged in the early 20th century, more than 100 years after the Second Amendment. Under Bruin, the lack of historical precedent renders state permit requirements presumptively unconstitutional.